All rise. Please be seated.
Okay, bring the jury. I'm admitting the exhibits over an objection. That's number 59, sorry, 57, 58. '57 and 58.
Thank you.
All right. There you go, Madam Court Reporter. Cross-examination?
Good afternoon, Dr. Grow.
Good afternoon, sir.
I don't have a lot to ask you, but I do want to ask you a couple of things if I could. Taser involved in this case, I believe you have previously, is the X-26.
Here it is, sir.
And please tell me there's no battery in this.
There's no battery in it.
This X-26 is the Taser involved in this particular case, is that correct?
It's the correct model. I can't testify about the chain of custody.
Okay, I understand that, yes, sir. Is an X-26 without a cartridge only a threat at close quarters?
Yes, although, thank you for bringing that up, because in the United Kingdom, and I'm thinking this because that's where I'm going to be next week, 80% of the time they get compliance because of the frightening nature of the weapon. So they will aim it at the suspect or the individual they want to control and have trouble getting compliance with, and they will turn on the device, and they get the laser pointer and the flashlight, and that, when they see that laser pointer, they're generally intimidated. It's my understanding that also happened with Officer Slager. And then if that doesn't do the job, then they will do the arc. And so they get compliance because of this psychological impact, the terrible fear of being shocked at a distance. But outside of the psychological impact, which works 80% of the time, you have to touch.
You have to touch, or I believe you, on your direct testimony, either make contact or very close to contact.
Thank you for that clarification. Right.
And Officer Slager, being a certified taser operator, would certainly be aware of that, correct?
I don't know what he's aware of or what he's not. I can tell you that that would be consistent with the normal training.
Because when the officer is trained, they're trained that a taser in close quarters is, without a cartridge, is only effective at close quarters, correct? In terms of delivering a shot.
Right, it can only deliver shock if it's within about 1 inch of the skin.
And it's not a threat at 15 feet
It works fairly well at 15 feet.
without a cartridge?
Yes, sir. The psychological impact of having that laser beam pointed at you and that arcing, that very loud arcing, it's pretty impressive, and the British data supports that.
I understand that, sir, but I'm not talking about John Q. Putt, okay? I'm talking to someone that is trained in a taser as you are trained in a taser. Is you being trained in the use of a taser, is a cartridgeless X26 a threat to you at 15 feet?
Yes, and it's more of a threat to me than a criminal suspect for 2 reasons. Number one, I've experienced it. I know I don't want to experience it again, and that would be a typical officer's gone through training. Secondly, if someone has cocaine in them or alcohol or some other illegal drug that functions as a pain blocker, that actual shock is not that bad. It's really not that painful to them.
And could you tell me how that is? How, if I have this taser right here, and I'm this far from you, could you please explain to this jury how I can shock you?
If you told me right now, get down on the ground, or I'm going to shock you, or I'm going to tase you, typically people say in the street, and I know that I'm sober, I have no cocaine in me, no alcohol, so I'm going to feel every bit of pain. Secondly, I previously experienced this, so I know what it feels like, and it's a lot worse than I ever expected. I'm going to listen to you, and I'm going to try and figure out how do I get out of here, maybe run through that jury door over there.
I understand
Or I
that,
comply.
but that wasn't my question, sir. My question is, how can I shock you with this taser, without a cartridge, from this distance?
Well, you can't electrically shock me. It's a psychological shock at this point.
Okay. It's not a trick question, sir. It requires contact, correct?
To deliver the electrical shock.
And you can't deliver one without a cartridge at 15 feet, correct?
That's correct.
Or 30 feet, correct?
Yes, of course,
55 feet.
of course.
And in barbed mode or prong mode, it's not necessary for both prongs to actually make contact with the skin for the taser to be effective. Is that correct?
Generally incorrect. There are unusual situations where one probe makes connection. May I stand?
Sure.
Let's say a probe were to hit me here and this increasingly sized target,
I
and
have that same problem.
the other probe were to get lodged in here, say I have seen this happen in the armpit area of my suit coat. And then if I move my arm down, it could arc through to my side. In that case, it makes a very distinctive burn mark it would make a distinctive burn mark on my skin because it's arcing right to my skin. So that's pretty easy to detect afterwards.
But the point is, a barbed taser deployment can be effective even though both prongs don't necessarily penetrate the skin, correct? They can't. In other words, at 50,000 volts, they can't arc through fabric.
Yes, sir.
And I believe you testified on direct that a drive stun can leave a mark on the skin, correct?
Yes, it usually does.
And it can also not leave a mark on the skin.
And let me correct something. Drive stun is longer than 2 seconds, it'll leave a mark. General rule of thumb, less than 2 seconds, it generally will not.
Okay, because it depends on the duration, correct?
The duration, yes.
Of the actual stun. And it also depends on clothing in between, correct?
You will get a drive stun mark with or without clothing. You actually get a little more of a mark if you have some clothing, because you have, the arc is formed, and the arc is where the temperature is greatest. And then when you get out to, say, an inch, when you're arcing through a bulletproof vest, you will get less of a mark because that gap reduces the current, but you'd still feel it.
The photograph that you showed to the jury earlier regarding drive stun burns, were those made directly to skin?
I have in my slide deck, ones were made directly to skin and some through clothing. So I'm trying to remember which ones were ended up being shown. I'm not sure right now. I had some of each. And
This is the one you showed the jury, I believe, correct?
yes,
Do you know if these photographs were taken of drive stun burns directly on skin?
I'd be more confident if I could refer to our book. May I refer to the book?
They're your pictures.
I didn't actually take them. I edited the book. I'm very confident that the pictures on the left were direct contact, and I'm reasonably confident that the ones on the right were through clothing, because we see more burning.
And it depends on duration and if the subject is moving around and if the taser is moving around. There are a lot of variables involved. Is that
Yes, sir.
correct? And so would you agree that it's possible for someone to get drive stunned and not be burned?
It's possible. It happens.
It happens all the time, doesn't it?
Can you quantify what you mean by all the time? Can you give me a percentage?
It happens, sir, correct?
It does happen.
Okay. Now, if a cartridge is not attached to the actual taser itself, but still have wires running from the cartridge to the taser prongs, can those wires or prongs conduct electricity?
They can.
Conduct electricity, but will the taser operate them if the cartridge is removed from the taser?
Usually not, but I have been in investigated situations where the weapon contacted the wires and the very thin insulation allowed some of that shock to go into the wire and then went out and shocked both the officer and the subject.
Okay.
It is unusual.
It would actually have to require contact with the electrodes or terminals or whatever you want to call them with the taser with the actual wire itself, correct?
Or the probe, or very close to the probe.
Okay. And I believe you also said on direct examination that it is possible that a deployment of a taser without the cartridge could destroy potential trace evidence on the electrodes or whatever you want to call them. Is that correct?
That's correct.
Is it also, the converse also true?
You could have a piece of trace evidence that survived arcing on the electrodes on the muzzle.
Yes.
Yes, the larger ones would tend to survive. Larger pieces of cotton tend to survive. Smaller pieces of polyester would tend not to survive.
Because really the trace would have to be kind of in the plasma arc, correct, to get burned up or at least very close to it, correct?
Yes. But you see how much the arc moves around, so I couldn't rule out any part of that electrode.
But the actual plasma doesn't transmit through the fiber itself unless it is a conductive fiber, correct?
It would, no, that's correct. It would go around it and engulf it and burn it up just from going around it or near it.
Okay. Now, also wanted to show you, hold on just a sec. I'd like to show this photograph that you showed to the jury as well. And could you explain what that was again?
On the left side, we have a white polyester fabric. The drive's done to with a gap. Now, the difference between my experiments and Ms. Fletcher's experiments was that I had intentionally put a half-inch gap, so I was able to get a nice arc. And so we have a hole that got burnt with a 5-second exposure, and we had a half-inch gap, the white polyester, and then conductive metal underneath that. Then in the middle picture, I show that blown up with millimeter scaling, and so you can see that the largest diameter of that hole or another hole in the experiments is about less than half a millimeter, so about 500 micrometers, which is very consistent with her number. I think it was 400 some micrometers. And then on the right side, have a very dark polyester, a high saturation blue polyester with a hole burnt in the same method.
Okay, and all of them involved conductive underpinnings or?
These did involve metal underneath.
And all three of them created holes, correct?
Yes.
And all three of them were 5-second bursts, correct?
I believe so. I'd have to go back and look at my records, but I believe those were 5-second.
Now, was it your testimony, sir, that and if I'm wrong about this, please correct me, but it regarded the body armor, is that a conductive surface or a non-conductive surface?
The body armor depends upon if you're over the steel plate. That internally is going to be conductive, but it's covered with paint, so it's not going to be conductive until you have a high voltage that would break down the paint. In general, the vest is non-conductive fabric.
And just mark this for identification, please, Norman. And I believe this was with your PowerPoint that you provided us previously. Is that the slide you provided, sir?
That's correct.
And what is that?
This was a test I did of arcing through a ballistic vest to look at how that affected the distance of the arc after it went through the vest.
Okay.
So I put the piece of paper between the vest and an aluminum plate, as the white paper would show the burns on the bottom. And you see that the spacing is only 2.5 centimeters, so it comes in at an angle as it goes through the vest.
Okay, so in other words, it did arc through the vest in your test that you conducted, and that photograph was taken from.
Yes, sir.
Is that correct?
That's correct.
Which presumably would leave a hole in any uniform, polyester uniform that was worn over that vest, correct?
Not necessarily. If it was a 10 or 15-second application, I would say yes, because of the 15-second application, we can get holes without backing. And having the vest in between the metal, in fact, I use my Kindle here to simulate the metal, and we'll use this towel from my hotel for the the vest. So I got the metal here, I got the paper sample here, I have the vest, and then we're going to have the shirt on top of here. So we'll just use this tie for the shirt, okay? And I arc down here. The current has to go down through the vest, goes in towards the metal, and then it's reducing the amount of current because I've got this arc here that's sucking up a lot of energy. And you might not see a hole there for a 5-second application. And that's an ideal situation. Now consider the situation where I'm Officer Slager. I don't have metal here. This is my skin, and skin itself isn't very conductive. The outer layer of skin, the epidermis, is like leather, and it's not conductive. You have to go down to the subdermis, and then it's fairly conductive, but nothing like metal, of course. And so we're going to get a lot less current, so I would expect it to take longer to burn holes in the polyester shirt.
Now, I'm a bit confused, because didn't you say on the direct examination that the plasma arc from a taser is hot as like 3 suns or something like that?
About 4. It's 35,000 degrees.
4 suns, and it arcs from the electrode from the tip of the taser through the fabric, correct?
Yes.
And so why is that not 3 or 4 times the temperature of the sun?
Well, in the example you just gave me, there wasn't a lot of gap there to develop a huge arc, but within the arc, that is approximately what the temperature would be. So it's very hot. That's why arc welding works.
Hot enough to melt polyester,
Eventually, but it still takes time. If you took a big kettle of water and you took a blowtorch that's at 1,000 degrees and you put it on the water, it still takes time to boil that water.
Now, speaking of time, was it your testimony that the taser will not arc through fabric, polyester fabric, unless there is a conductive surface underneath?
No, it was not my testimony. It would prefer to do initially a surface arc, but eventually it will jump around because the electrical arcs or plasma, as you more technically referred to it, they are variable. They move around just like lightning, and eventually it will go down and burn a hole by finishing the arc on the opposite side of the fabric. And that's what Ms. Fletcher showed. With 15 seconds, she was able to get nice holes even without metal.
Did you not understand Ms. Fletcher's testimony that she was able to get these holes even with a 1-second burst against non-conductive surface?
I'm very sorry if I wasn't clear to you, sir. There's a big difference between the metal and the non-conductive, and I've looked at her data in her report, and in general, it's consistent with my research. You get the holes in the fabric much more quickly if you have the metal background, because then it forces the current through there. And there is another variable, which is how hard you push on the fabric. May I use the weapon for a second to explain what I'm trying to point out? Because I think you raise a very important point, and I think the jury should, thank you very much, sir, understand this. If you just are pushing, say, against a human being, things are kind of bouncy and soft. You can't get that much pressure, so you're not going to get as good of a contact. If I am doing this, pushing against, I believe it was a Formica countertop, I have very good contact, and I'm doing something else. I am distorting that fabric. So the fabric might look like this. Where I've got the contact, I'm thinning it out. And so I'm going to get a preferential arc there, with or without the metal, and it's more likely to burn through there. So we really have kind of three steps here. One is high pressure on metal, you're going to get a hole very quickly. Then high pressure on Formica tabletop, you're likely to get an arc very quickly, but it's still going to take longer. And finally, you've got pressure against the softer things like ballistic vest, and that's going to take much longer.
Okay, well, let's assume, since you testified to this, that it was a 5-second burst against a linoleum countertop with a replica of Mr. Officer Slager's uniform shirt on top of that. And I want to hand you what's been previously marked as State's Exhibit number 254 in evidence, and ask you, does this appear to be a hole?
Which picture here?
Bottom picture. Does that appear to be a hole?
Yes, it does.
Okay. Next page. 4-second burst, no cartridge, non-conductive surface underneath. Does this appear to be a hole, sir?
Yes. Well, this one's harder to say because it looks fairly similar to the fabric gap here and here. So this one, could we put this up on the screen for the jury to see?
And it's a different magnification too, correct? That's 66 times instead of 100 times like the other one was?
Yes, and it's impossible to, probably better to have Ms. Fletcher testify about her pictures.
I believe she did. That's why I'm asking you these questions. And a 3-second burst, linoleum underpinning. Does that appear to be a hole?
Thank you. Again, based on this picture, and can we put this up on the screen? Because I think it'd really be helpful for the jury to see us. Because
It's in evidence. The jury can see it all
okay,
they want.
I think I've got pretty good vision, and I couldn't tell you if that was a hole or that was a hole because there's a lot of black gaps in there. So
Well, she's a trace expert, correct? And she said it was a hole, a burned hole. Do you dispute that?
I never got a chance to see this fabric through the microscope, and so I can't dispute it or disagree or agree.
And in 2 seconds, I believe she testified that was a hole.
Did she say anything about these other gray marking areas here?
When you get on this side, you can ask questions. And how about number 5, which is a 1-second burst, that she
Thank you.
testified that was a hole?
I'm seeing 3 areas of gray splatter here that could be holes or could be splatter. Which of the 3 would you like me to comment on?
The one that she's got measured and the one that she testified was a hole, so burned hole.
I can't say. I can't see how you would differentiate that from the other ones. It might be, it might not be.
Thank you. I have nothing further.
Thank you.
Redirect.
Thank you. Professor Kroll, when you did your experiment regarding the ballistic vest, and I'm not even going to call it an experiment, you were just messing around with a ballistic vest, correct? To see if you could make, get an idea if the metal underneath helped conduct the arc through there, is that correct?
Yes, sir.
Do you know if that was the type of vest that Officer Slager wore that day? Did you do any of that, or did you just get a vest?
I have a point blank brand vest, and that's what I used. But the basic principles are the same. There's a Kevlar material. And so if the, could we look at this vest right here? I could describe it on this one in evidence.
Now, this is an exemplar vest, Mr. Kroll. This is not the one worn by Officer Slager, but feel free to.
It's my understanding that the vest was lost in evidence, but we can use this as an example. If we had a shock delivered here, this is a solid plastic insulated area, and we would get the surface burn, and you cut right through there. And I verified that with this type of vest last month. But of course, if you wore something like that in Charleston, you would be very sweaty and very uncomfortable. So these are designed to have big areas for breathing. And so a shock here would go through, and a shock here would go through, but over here in the insulated areas, it would tend not to go through, and you would just have the surface burns.
And I note in here, thank you, that there is a taser, exemplar taser, that is in there, and it had a battery in it. You're 1-0 today on not getting tased when you give a demonstration. Would you be willing to see if this battery would operate that taser to give the jury an idea of the arc and how it moves, as we previously were going to attempt to do?
Yes. Thank you. Okay, there is no cartridge in here, so there's nothing to shoot out. Okay? And I would like to point it at the jury so you can see what Officer Slager would have seen with the lights.
Why don't we start at the wall first?
Okay. All right. Oh, we're 0 for 2.
0 for 2?
Another dead battery, sorry. Oh, for all that build-up.
Give me that so we don't get these mixed up. And you said that probes make a distinctive wound when they enter the body?
They do.
And is that, if there's a connection, if there's a good probe connection, does that wound have anything to do with the transmission of the electrical current or the arc?
Yes, sir. If the probe actually lands in the body, we have a very distinctive shape because we have a 1 millimeter injection site, if you will, like a shot, and then there's the collar around the outside, so it looks just like a donut, basically. If the second connection is not with the probe in the skin, as a State's counselor brought up, you can get a connection by arcing through the skin, through the clothing, forgive me, and then you get a nice burn from the arc.
And is there a way of looking at a probe itself to tell whether it's ever conducted electricity through it?
Yes.
Explain to the jury how you would do that.
Do we have a probe to?
There are some probes in evidence. I'm not exactly sure.
I can try to describe it. If you could hand it around to the jury, it's much easier for them to look at it.
Well, why don't you start describing, and I'll try to stay out of the way and see if I can find an exhibit number, and maybe I'll be a little more organized here.
Imagine a hand sewing needle. There is an eye of the needle in the back. That's what the dart looks like. And the wire comes in and it goes in that eye of the needle. It's not soldered in. It's just a knot there. And so if you pass current through the probe, the insulation melts off, and it starts splattering metal. So after an incident, you can look inside the eye of the needle with a scanning electron microscope, and you can see if the probe passed any current or not. If the eye of the needle is perfectly clean, then we know that no current was delivered.
Make one more pass through here, but I think we may be at a loss. Do you know if there's a picture in either of your books that explain that
Oh,
phenomenon?
certainly.
Could you,
I'm sorry, I left them in my briefcase back in the bleachers.
would it be the book on the Taser?
Oh, I think we have it here. You have the wound book?
I,
Okay.
Respect, Your Honor, this is beyond the scope of my cross-examination.
Your Honor, he was asking about if you could tell whether a probe hit and a non-probe hit could provide an effective shock, if you will. The question was, yes, it could, or pardon me, it was answered, yes, it could, but it would generally result in some arcing that would result in a mark on the skin. This is an alternative way, so the implication is if one probe is in and the other one is closed, you'll still get it. There's an alternative way to determine if electricity was delivered, and I think it's relevant to the jury to understand what that alternative way is, if it was or was not explored during the investigation of this case.
Mr. Durant?
I stand by what I said, Your Honor. You acknowledge that you did large reflow?
Sir? I couldn't understand what you said.
I said, I'll stand by what I said, Your Honor. He said on cross-examination that if one probe's in skin, another one is not, it can arc through clothing and cause a shock.
I overrule the objection.
Thank you. I'm going to show you
You was in the witness.
yes, Your Honor. I'm sorry. I was just trying to have the faith. I didn't want to surprise them. I'd like to show you figure 10-16 and just ask you if that is the knot that you're talking about.
Yes.
Okay, and Your Honor, we will provide a copy of this for defense exhibit for ID, but we'd like to just publish it to the jury on the envelope if we could.
Any objections to these?
No, Your Honor.
And would you once again explain to the jury what you were talking about with the eye of the needle and what physical changes you might see in there if electricity were to pass through it?
Well, this is obviously blown up dramatically, so you see much of the probe, but the probe starts here. Actually, the sharp end is down there, and the back end is here. It goes out here to the thick, heavy area, and then the needle starts out there, the spear part. And so the wire comes in the back, and then it is knotted inside there, and that is the eye of the needle, and that's where we would see splattering of insulation and metal if there was current carried.
And what causes the splattering of the metal?
There is no soldered connection. And so if you've ever connected something like a car battery, you bolt it right on its direct connection, or you solder something that's metal to metal, the wire has insulation on it. It's very thin insulation, and when that voltage hits, then it jumps through that insulation, splatters insulation inside the eye of the needle, and then the voltage difference actually causes metal to be plated It's similar to the process called anodization, where you use electricity to track pieces of metal and coat, like the, those, if you see, I'm not seeing any aluminum railings, just beautiful courthouses, all wood. But nice metal window frames, those are usually made by electrical coating of metal, like that.
Okay, and finally, Mr. Durant talked to you about the presence or the absence of holes in fabric as an indicator of whether there was a taser drive stun. Is the presence or absence of holes dispositive to determine whether a taser has been applied to fabric?
No.
And would the, for lack of a better term, would the arc prefer to go through air than to blast through fabric?
Yes,
And why is that?
because there's no interference and there's a wide path. But, I mean, to be fair, if I have metal behind that, obviously it's better to go down, catch the roll of the metal and come back up. But if I just have fabric in the air or on formica, then the closest path is that straight, basically first base to second base line, although it's a jagged jump, versus going down to the fabric, going the other side of the fabric, going out, and then coming back, which it will do eventually. But it prefers to go directly at first.
And one last question. We talked a little bit about perspiration. What effect does that have on the transmission of the arc, either on top of or through the fabric?
The salt water is a very good conductor, and sweat is basically salt water. So if you had sweaty clothing, it could be a good conductor, and you would not have the arc because you got the salt water pulling, allowing the current to pass right through the clothing. So it can pass directly through the clothing gaps with the salt water, and so there'd be no arc and there'd be no burn.
And finally, is it possible to mistake a drive stun for some other physical contact due to the neurotransmission that you talked about earlier?
In the sense of a pain sensation or various sensations we have?
Yes.
Well, it'd be, you could confuse it with other electrical stimulations, but not, you couldn't confuse it with you know, I don't think I understood your question.
Okay.
Right, can I start? Let me start over, okay?
Let me rephrase it for you.
Okay.
Is it possible for you to get drive stunned and perceive a drive stun as a different stimulus?
Yes, because you excite all of these nerve fibers, the ones that tell you vibration, pressure, temperature. Can I tell them about, in my experience, when I took it across the chest, I thought somebody was inside me trying to kick out. I thought my chest was exploding because all these nerves are being stimulated and you can't really understand what's going on because it's not a natural sensation.
Court's indulgence? Or Professor Kroll, if we were able to come up with a battery to power that taser, would you be willing to be recalled because for the purposes of you as a taser expert firing that for the jury?
As long as I don't have to take it on me personally,
Yes.
yes, I'd be happy to do that.
No further questions, Your Honor. And,
Further in the road. Recross.
Very briefly, I believe the experience you were explaining was when you were bar stunned, correct?
Yes, sir.
Okay. Which is obviously painful, and being drive stunned is obviously painful too, correct?
Yes.
And I'm assuming from your experience when you did it to yourself accidentally, you didn't have any problem understanding that you drive stunned yourself.
At first, of course, but what the first reaction is I didn't know what was going on. All I knew was I was screaming in front of the judge and the courtroom, and the weapon fell and the Coke can fell. It was, and then I figured out what I had done.
Because it hurt.
Yeah, but the pain is really not like a normal pain, like say a hammer on the finger or a hot candle or something like that. And it was right in front of me, so I could very quickly go, oh yeah, now I know what happened, because I could see that.
And because you could see it and you were holding it in your hand, correct?
And it was all my fault.
Thank you, Doctor. I have nothing further.
Thank you. You may step down.
Thank you, Judge.
Call your next witness.
Defense calls Amanda Hazelton.
Do you swear affirm the testimony you shall give the court and the jury in the trial in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Please state your first and last name, and spell last name loudly, clearly, and correctly.
Amanda Hazelden, Haselden.
Yes, sir.
Good afternoon.
Good afternoon.
It's Mrs. Hazelton.
Mrs., yes.
And if you would, please, Mrs. Hazelden, introduce yourself to the jury by way of education, profession, both academic and experience history.
Okay. I am a lawyer here in Charleston. I received my undergraduate education at the University of North Carolina at Chapel Hill. I went home and worked for a year in Atlanta, Georgia. I then started Charleston School of Law, where I graduated and passed the bar in 2007. The first 4.5 years, I was a prosecutor with the 14th Circuit Solicitor's Office under Duffy Stone. The first 6 months there, I was a basic small crimes prosecutor in Beaufort, South Carolina. After that point, I transferred up and was in the Walterboro office in Colleton County, where myself and the deputy solicitor, Sean Thornton, started the career criminal team. We prosecuted mostly repeat offenders and large, they're considered serious or most serious crimes under the law. So a lot of murders, attempted murders, things basically that we were looking at either life without parole, death penalty, or very high sentences. I wanted to start a family, so I left that position in 2011, started my own firm here in Charleston, Stokes and Hazelden, with my law partner, Julianne Stokes. We do by far and mostly family court work now. Probably 90% of our practice is family court. I still do take a little bit of criminal defense work, a couple of cases a year, but mostly family court. And I've been practicing still mostly here in Charleston, but I also handle Berkeley, Dorchester, some Colleton County cases. Anything else?
Thank you. And so in summary, you're familiar with both criminal cases and family court matters, is that correct?
Yes, sir.
Do you have any relationship with the Savage Law Firm?
I went to undergraduate and law school with Scott Bischoff, who works in your office, but I probably haven't seen Scott in a year. We send each other text messages during basketball season about the Tar Heels. But no business relationship, nothing further than just we went to school together. We know each other.
Do you have any professional relationship, or did you have any professional relationship with the Scott family, including Walter Scott?
No.
Do you have a familiarity with the system employed in the Charleston County Family Court with respect to child support payments?
Yes.
And if you would give the jury an outline of how that works.
So anytime there are minor children involved in a family court case, as probably just about everybody knows, if it's not their own personal experience or somebody else's, child support is going to be ordered or agreed upon by the parties. The most typical way that it is handled is it is paid directly from one party to another. But there are certain situations where an individual might be required to pay through a court. At that time, they pay through the clerk of court's office. It has to be in a court order that they're required to pay through the court. And a surcharge is attached there too. I believe it's 5%. And child support can either be a number agreed upon by the parties, but most typically it is reached in a child support calculation. South Carolina, like most states, uses an income shares model, which is basically an algorithm, an equation. Basically, I type it into the computer, you put in various amounts, gross income of the parties, and how much this person might pay for child insurance, or the child's health insurance each month, if there's any work-related child care costs. All that is taken into account, and a number is spit out, and that's generally what is ordered unless one party has a really compelling reason to deviate from that calculation.
So that number, whatever it is ultimately ordered by the court, by a judge?
Yes, sir.
And typically it would be reduced to writing?
Yes, sir.
And in arriving at that number, the financial status of both parents, mother and father, are considered?
Yes, sir.
Ability to earn income, type of income earned, expenses that they have, and then a figure is arrived.
Yes, sir.
And you say that it's a standardization in South Carolina to arrive at a specific number?
Well, South Carolina and most states use this income shares model. I can't speak to other states, but it can be adjusted periodically depending on cost of living. I think there was just a cost of living increase in South Carolina a year or two ago, so that number was tweaked a little bit. But certain states, like maybe New York State, I think still uses a percentage, like a flat 20% of the payor parent's income is used, but we use that basically computer program.
But in Charleston County, it depends on the circumstances of the parties involved. Is
Yes.
that correct? And also the needs of the children.
The needs of the children are taken into account through that, if you include the amount required for health insurance and child care.
Now, there has been some reporting in this courtroom, in this trial, that there is a debtor's prison. Is there such a thing in South Carolina?
No.
And tell us how the court in South Carolina, family court, enforces the collection of the children's funds if one is reluctant or does not follow through on the court directives.
Through a private enforcement action or the clerk of court's enforcement action?
Through the clerk of court.
Okay. So if somebody is required to pay through the clerk of court is actually required by the rules of court to go through at least once a month and do an accounting, and if anybody has an arrearage against them, they bring what's called a rule to show cause. It's a little different than if somebody who was having child support paid privately would do it, then you or a lawyer on your behalf would have to file the rule, but the clerk can actually file a rule to show cause and issue the rule to show cause himself, or here in Charleston, herself, Julie Armstrong. She does still have to present certain evidence, but she can issue that rule to show cause, which basically gives that person notice and tells them time and place and what's been alleged against them in the court order that they've specifically been alleged to have violated and how they violated it. And a hearing would be scheduled. The person would have to be served with notice of that hearing, and at that hearing they would proceed. It's an evidentiary hearing. It's basically like a mini trial. And the person, the clerk's office would present their case through the parent, basically, that's supposed to be receiving this support. And then the person who's alleged to have violated that has an opportunity to respond.
Based on your experience in both criminal court and family court, is there a difference between an arrest warrant and a bench warrant?
A bench warrant in family court?
Yes.
Yes.
And would you tell the jury the difference?
Okay. Well, an arrest warrant is a criminal document at its most basic, and a bench warrant in family court is a civil document. It is, it's a mechanism to enforce the civil contempt powers of family court. So even though it is a valid warrant to go out and place somebody legally under arrest, it is a civil document at its heart. So once somebody's picked up and confined, they're brought back before a family court judge. They're not taken before a bond judge to be dealt with as the family court sees fit at that time, depending on the circumstances.
And when somebody is picked up on a bench warrant, what is the process? What does the court look into after a bench warrant is served on somebody who hasn't paid their child support?
Well, each case can be a little different, but if somebody's picked up, there's been some sort of finding or allegation that they have not followed the court order. So with terms of child support, there's going to be an allegation they didn't pay their child support on time. And then they either failed to show up for that hearing, which is the most common reason, and the court is basically enforcing their presence there. So there's usually a certain day of the week or month, depending on which county you're in and how often you have court, that, you know, all these parents that have been incarcerated that month are brought back before the judge one by one, and they have hearings, and they're given a chance to present their side of the story. You can't be held in contempt for non-payment of child support if you cannot pay child support. If you are unable to pay, that's case law in this state. It has to be a willful and knowing violation of a court order. And, you know, quite honestly, sometimes people just can't pay. They just simply can't pay. So they, but what the court's ultimate goal is to get that money for child support. The whole purpose of civil contempt through a rule to show cause is to exact compliance with that court order. At the end of the day, the court wants that child support money because that's in the best interest of a child, and that is the overarching goal of all family court proceedings involving minor children.
Do people who willfully and intentionally violate court orders automatically go to prison?
No. It is always in the discretion of the court, even once they've found that somebody's in contempt. So that's the first thing. They have to find somebody actually in contempt. Even then, it's always in their discretion as to whether or not to actually order sanctions or not.
If somebody is found in willful violation of a court's order, can they be given community service?
Yes. The statute on point in the state, actually, I think it's 63-3620. And it's on the bottom of all of our family court orders, the wording of that statute, so people are on notice, or it was required to be after a certain date. They can sentence you, if they find you in contempt, you can be sentenced for up to 1 year in a local detention facility, not a CDC, up to 300 hours of community service, and up to $1,500 fine or any combination thereof.
Even after somebody would be sentenced to that, whatever penalty that would be, can they come back to the court under new circumstances of employment opportunities or whatnot?
Certainly. You always have the opportunity to purge yourself of your contempt. And in a child support situation, it's going to be pay the money.
So if somebody on an arrest warrant is convicted and sentenced to prison for, say, a certain period of time, one cannot come back and ask the court to reconsider that sentence. Is that correct?
For the most part, I think everybody in this room could, all the lawyers could probably claim. There's a few situations, you know, if they wanted, I think within a year, they can come back and claim they have new evidence, or they want to help out in other situations, they can come back. But for the most part, I think you're correct.
Lawyers.
Lousy lawyers, that's right. We ruin everyone.
In family court, on a bench warrant, if somebody's even found in willful disobedience to the court's order, and let's say they got the maximum penalty, would one ever serve the maximum penalty?
Well, you're given credits. So most people hear about somebody being sentenced to crimes. You only do a certain percentage of the crime. You can get good behavior credits. And the statute for the max penalties of contempt state that people can get good time credits, they can get work credit, they can, I would guess they would get credit for any time they've already served, so the chances are small, but it would be a case-by-case basis of actually serving a full year.
And again, that wouldn't be in a Department of Corrections facility.
That's correct, it's a local facility.
And are people who are employed at the time that they are taken into custody on a bench warrant allowed to continue their employment so that the children can get the money from their paid job?
Well, again, it's a case-by-case basis. Everything is, totally dependent on what happens in court that day. But for the most part, the goal is to get that money. So the court has a really hard time locking somebody up that has the opportunity to pay, the ability to pay through a job. So a lot of times they can, especially if asked by a lawyer, they'll do weekend time. So you check into jail at like 5 o'clock on a Friday and you get out at 5 o'clock on a Sunday or whatnot, but you're allowed to go work during the week to try it, because again, the goal is to get money. The goal is to get child support.
If somebody was behind in their child support payments of a substantial amount of money, $1,000 or two, whatever, does that all have to be paid before they're discharged?
Not in full. Again, the court can allow somebody to purge themselves of their contempt if they order confinement. They can, sometimes they'll require the full amount be paid. If it's a really extreme amount though, and this isn't a person of, great wealth, which it's usually not, or they would have paid the money in the first place. A lot of times they will establish some sort of amount that they have to pay, and then they will put them on a payment plan of sorts. They'll add an additional $7,500 to each additional payment thereafter. That's pretty common, in my opinion.
Now, were you asked to review the family court file of Walter Scott?
I was.
And tell the members of the jury what you reviewed.
I would object to any testimony concerning Mr. Scott's particular case, Your Honor. I think that it's irrelevant. The whole issue here is whether or not what happened to him with the bench warrant.
And that's correct.
I didn't hear the question. Let me hear it.
Have you had an opportunity to review the family court file of Walter Scott?
And the answer.
Yes, I was given the 2000 case file.
I continue
The
to.
objection is overruled as to that question.
Did you have an opportunity to evaluate the court orders in that case?
Yes, I did.
Did you have an opportunity to evaluate?
Objection, relevance.
Ladies and gentlemen, we'll take a break now. Okay, let me hear your objection.
My objection is relevant, Your Honor. The particulars of Mr. Scott's family court situation is irrelevant to any issue that this jury has to determine. The only issue is whether or not he had an outstanding bench warrant. And also, this is getting into what we filed a pretrial motion about, character evidence. All he wants to do is smear Mr. Scott's character by establishing that he didn't pay child support, and this is how much child support he didn't pay, and this is why he didn't. This is when he didn't come to court. All of that is just pure character evidence, trying to make it look like a deadbeat, and it's not relevant to any issue that's before this jury.
Savage.
In Solicitor Wilson opened an argument on the first day of trial, November 3rd, she said that Mr. Scott was trying to avoid debtor's prison, her words, not mine. And since that time, during the state's case, they repeatedly showed that the provocation for the disobedience to the police officer and running the failure to stop was because he was trying to avoid the consequence of being arrested for child support. That was something that the state determined. We didn't suggest that. We believe that this is relevant based on the state's theory of why Mr. Scott ran.
You want this witness to confirm that theory, dispute that theory?
We want the jury to know that it's not an absolute, so that the inference that has been brought before this jury is that if a bench warrant has been issued, someone's going to get his jury.
Well, you've asked her that. That was unobjected to.
And what she has reviewed will confirm that the status of Mr. Scott's family court bench warrant on April 4th was not that he would be placed in prison for confinement at all, but that he would have the opportunity to go back to court and explain why the child support requirements were not met, because the circumstances of that
Hasn't she already said that?
about others, but not specifically about Mr. Scott.
Yes, sir.
My response to that is it's not her decision to make, it's family court judge's decision to make, and she's already said that. So basically, the specifics of his status with the family court is irrelevant for his purposes.
What was his status with the family court?
He had a pending bench warrant.
All right. Well, hasn't that been acknowledged or conceded or?
That I have no objection to, Your Honor, and that's why I haven't had any objection to her testimony concerning what happens to someone in the family court.
Yeah.
Specifically, Walter Scott Jr. said he cautioned his brother not to buy a Mercedes because North Carolina, Anthony Scott apologized, not to buy a Mercedes because he would be picked up by North Charleston. The influence that he would be going to prison for some period of time. And that's the state's theory.
You've argued that, and we've already discussed that just a moment ago. Question is whether or not she should be limited to say he had an outstanding bench warrant. She's already probably gone far and beyond her expertise in declaring what a judge would do under a specific circumstance. And so I believe that she has, other than saying she reviewed the file, he had an outstanding bench warrant. I don't know how much more you could get out of this witness.
That in accordance with her review of the file, that Mr. Scott would have been brought back before the court has a number of options to employ if he were to be found.
If he had a bench warrant, he was going to jail. That's what a bench warrant is. You don't go back before the court, you go to jail. Now, at some later point in time, so you want her to again explain this process, that once he's in custody, then at some future time, she's talked about the people who haven't paid child support are brought back and offered an opportunity to offer mitigating circumstances, pay the back support, and many other options. I'm not sure. You want her to repeat all of that once again as to Mr. Scott?
She has testified generally what the evidence is, but I don't believe it's a correct statement of law that somebody who's picked up on a bench warrant is placed in jail.
Well, they are. That's what a bench warrant is. An order, it's an arrest warrant. You go to jail. There's a bench warrant. You don't pick them up and take them to the judge. You take them to jail.
Step one, if it's in the middle of the night, if it's on the weekend, but there are cases before the court, the first opportunity that the family court has to give their case. It's not optional, it's automatic.
All right. We'll take a few minutes.